Now the next chapter is with reference to the presumption of the documents. Now documents just now were defined, were understood in details. What is this presumption? And you will be surprised to know there is no such kind of the definition provided so far as the word presumption under the Evidence Act is concerned. But there are certain authors like Professor Stephen. He defines the concept of presumption and he say presumption is a rule of law, and that court or judges who are dealing with the case in particular has to draw the inference of the particular facts based upon the evidence, uh, uh, unless and until that particular fact or the inference is disproved, the court can prove it. That is called the court can presume it. This is the only authorized definition available so far as presumption is concerned. So coming back to the Indian Evidence Act, under Evidence Act there are three kinds of presumption provided. One, that is the rebuttable presumption. Secondly, irrebuttable presumption, and lastly, the permissive presumption, or sometimes we call it the conclusive also. Now, what is these all the three aspects? We'll discuss different aspects. Section 79 to 90 of this Evidence Act deals with the presumption of documents, and these presumption, so far as documents are concerned, those are rebuttable presumptions. That means the party can disprove that particular proof by adducing some other evidence, and therefore it's a rebuttable presumption. Whereas there are certain provisions like section 41, section 112, 113, and 114 of the Evidence Act. Those deals with the irrebuttable presumption. Those presumptions are conclusive proof. There is no need of for giving the other evidence. And as I have already discussed in earlier lecture, that the sun rise to the east, no need. It's a conclusive proof. There is no need. No one is allowed to supposed to prove the evidence uh, on the record. It's therefore it's called as the irrebuttable or conclusive proof of evidence. And those provisions that is under this chapter, that is presumption of documents, are concerned. Again, this chapter is divided into two different aspects. There are certain provisions under this chapter, that is presumption of the documents are concerned. Uh, that some of the provisions under the law which are binding on the court, and therefore the words, whenever the word is used under the word shall under any section, it means it has some binding nature, bindingness over the court. Court shall presume. So it's there is no choice with the court. Court has to presume that certain rules are in existence, and therefore court cannot draw the inference, his own inference. Especially when we discuss the first part of the this particular chapter, that is the presumption of document, section 79 to section 85, they are deal with these types of the mandatory provisions, that those who are mentioned with the shall, the word is used shall. It's a mandatory on the courts. They have to presume certain facts. And rest of the section, that is section 86, 87, 88, and 89 and 90, where the word may has been used, where there is a chance of the court may ask the parties to prove the certain fact, to produce certain kinds of evidence in the court of law. So with this background, let us start with the discussion of mm, the concept, which what we call the presumption of the documents. Please bear in the mind, we are just discussing the presumption of documents under this chapter. We are not discussing the entire presumptions, because there are different aspects provided under the Evidence Act, where it's different presumptions are provided. So this particular chapter is only for the presumption of the documents. Let us discuss where the law has provided the presumption of the documents, and when it is mandatory and when it is not. So we'll discuss the first aspect, that is where the word is used shall. There is no choice given with the court. Court shall presume it. And the first aspect is that the presumption as the genuineness of certified copy. This is what section 79 says. So what is certified copy? We have already discussed under the earlier chapter. If suppose any party has produced the certified copy comparing from the copy of the any documents that is from the legislature house, court, or any other officer of the central government, state government, or local authority, or the fact having the seal and signature of the particular officer who is empowered to give it. In that case, the word is used. The court shall presume that the certified copies produced on the records are are the genuine documents. Now, I will take a pause here. Sometimes the question may be raised in the minds of the students that even if there is a word is used shall, does it mean that there is no scope available to the court to take the further evidence, or does it mean that the other parties having no authority to lead the evidence in this particular case? Yes, the other party has, the court has right to allow the other party to take the evidence, but the only difference is the whenever it comes under the provisions up to 79 to 85, it has some legal weightage to the documents, and therefore to disprove the statement, the more efficient, rather more believable evidence is required, and therefore the burden is heavy burden is lies on other party, and therefore if someone comes to the case, sir, that particular xerox copy, I'm sorry, that particular certified copy is not genuine, the other side, the person who produced it, he has made the false seal, he has signed false signatures, and then in such a case, if this such kind of serious allegation has been made by the party, then he has to rebut the presumption, and that too with the heavy burden. So the only difference is whenever there is a word used, shall is used, there is a heavy burden on the party who says it is not correct or who is disproved. So with this, we'll proceed further. So the basically section 79 based upon the statutory presumption that whenever there is a certified copy found by the parties, then it is a statutory provisions. It's a legal provision. Then court has to believe that those documents, those certified copies are genuine one, and based upon these uh, documents, court may further proceed in the document. Like take the example of certified copy of the birth certificate or death certificate is the best example to section 79. Next aspect, that is with respect of the uh, presumption in respect of the document produced in the court of law. Now here, uh, again, there is one trick provided that unless the contrary is proved, that is what the word is used, that unless the contrary is proved, the court can presume that whatever document is produced by the parties in the court of law, that is being produced or taken in accordance with the law. See, please bear in the mind, section 80 doesn't deal with the genuineness or presumption of document. It simply says the way they are produced in the court of law, the person who has produced the documents in the court of law, he must have he must have taken the document in accordance with the procedure established by law, like certified copy. What is the procedure provided? He has to apply to the authority, and that authority will be issue the documents. And under section 80, it is presumed that whenever the certified copy is filed on the record under section 79, the person has applied the certified copies, and by using that particular method, the person has filed a document. This particular procedure is being presumed by the court unless the other party comes to with the case, sir, the document, the way he has filed the document is absolutely wrong, and therefore if you summarize section 80, it simply gives the sanction of the principle under section 79. I'm using the word sanction or the principle of the section 79. Why? Because uh, the provisions of section 80 they are applied only to two classes. One, those documents which are on the record as an evidence, that is by the witnesses or by the in the judicial proceeding, and secondly, that the it's a confessional statement of the accused person, uh, like we have already discussed in the section 24. So court presume that whenever there is a confession is required under section 164 of the CRPC, or with reference to section 25, 26, 27 of the Indian Evidence Act, then court will presume that the confession is recorded is a genuine one unless contrary is proved, and therefore uh, So far as section 80 is concerned, there are three kinds of presumption. One, the presumption of genuineness of document. Secondly, the statement is recorded in accordance with the law, like we call as the confession statement. The procedure is provided in section 164. And lastly, the statement or the confession signed by the person who has signed by the person. So all these three presumptions are available under section 80 of the Evidence Act. Apart from the section 80, there is another mandatory provisions provided under section 81 of the Indian Evidence Act, and it is very easy. And even in our day-to-day life, we are using this, we are believing this. Take a simple example. If you understand after this, after reading section 81 itself, section 81 provides that there is a presumption of genuineness of the gadgets, government gadget, the newspaper, news in the newspaper, private act, or the parliament and the documents. Now, what is this? If suppose, if suppose in the proceeding someone produce the gazette published in official gazette of these, either it is central government, state government, or by any other local authority, then section 80 provides that the court shall presume that the contents in the gazettes are genuine, they are original, and having its legal value. Not only this, not only legal position. If you read the section 81 carefully, then it says that the gazettes of the England, sometimes if the it may happen in any proceeding, there is a clash because most of the our law we have borrowed from the London, that is the British government, and but therefore the subsequent question arose whether this documents is genuine one or not. And if someone produced the gazette from the British government stating that what is the intention of legislature, then in such a case, that particular documents the court shall presume it's a genuine one. And same in case of newspaper. Suppose newspaper has published any particular news. Take an example that tomorrow the newspaper has declared that tomorrow is the holiday, and based upon that newspaper, someone is absent from the office, and issue arose before the court of law, and he come with the case, sir. Based upon this news, I believe and I acted upon. So these kinds of presumption is there. So therefore, the court has to believe under section 81 that unless contrary is proved, the news in the newspaper is genuine. Same in case of the gazette published on electronic format, because you are aware nowadays, since the government is applying the less paper policy in the government office also, so everything is computerized. And tomorrow if suppose any rules, acts, obedience, or the any gadget has been published by the state or central government or any other local authority, and instead of publishing on paper, that is published on online, and it is circulated. So as per section amendment section 81, it says court shall presume the copy, if the copy of that gazette is produced in the court of law from the particular authorized website, authorized link, then court can presume that that particular copy, the word is used shall, is a genuine one, and that can be used under in the court of law. The most important aspect, so far as this particular chapter is concerned, that is provided under section 83. That is in respect of the presumption of the map, the plan, or the measurements carried out by the authority of the government. Now, if there is a map, and but it's not an ordinary map, it's a map created by the central government or state government, or the officers or authority under the central or state government or local authority, then the map can be believed or court can presume that. Why? Because sometimes it happen. Like last more than 40 years, there is a disputes between Maharashtra and Karnataka regarding the territories. Uh, Most of you are aware regarding the disputes, and there is an arbitration proceeding pending last 40 years before the not only arbitration proceeding, but the several proceedings are pending uh, in the Supreme Court and various high courts in India regarding the boundary. So, if someone, in order to prove their claims, the map or the plan submitted by the that is government plan, court can presume. I'm using the word the planned. So far as the plan of the central or state government machinery, it's not a private architecture plan. Section 83 is nothing to do with the private architecture plan. This presumption is available to the government map. If suppose tomorrow you want to file the complaint against your builder that he has not carried out the measurement properly and his plans is not correct, rather his architect's plan is not correct, then in that case the provision under section this particular section is not available. You might be remember that under section 36, yes 36 of the Evidence Act, we have already discussed the concept of the plans and made under the government authority. Then it has a presumption value. So this is the fourth kind of aspect which court has to presume. If it is a government plan, then court has to presume. Then come to the next presumption, that is the presumption in respect of the laws and the copies of the decisions. I'm not talking about the precedent, the decision. That is, if there is a certified copy, or the copies or the judgment is given or published in some books, like when you start to the practice, or if someone asks you to find out the authority, and you go to the library and you find out AIR, Criminal Law Journal, all Maharashtra law reported, then if that copy is produced in the court of law, then court can presume that that particular judgment is the genuine one that can be presumed by the court, and therefore the collection of the laws, as we have already discussed under section 34 also, that the collection of laws, rules, or the laws written in the books, or the books means the authorized books, not ordinary books. If it is written in published book, or those the right books with the copyrights, then the laws are very the court can presume it. Those laws are genuine one. And lastly, so far as the presumption as to power of attorney is concerned, now if the power of attorney which is notarized before the notary officer, or if it is registered, or if it is registered before the magistrate or to the registration office, or sometimes to the judicial officer, or if it is a foreign power of attorney, then in the Indian council, or to the vice council, or to the any other council, and if it is produced in the court of law, then court believe that the power of attorney is genuine one, and the person who has produced the power of attorney, he has an authority to produce that power of attorney. So this is what the section 85 is saying. The person who is representing himself or acting himself as the power of attorney, he can that presumption can be drawn by the court. Same in case of the new amendment is being carried out with reference to the 85A regarding the electronic agreements. If all the genuine documents has been produced and signature is there, that is genuine agreement, then court shall presume that all these electronic agreement and signatures are genuine one, and such can be that can be used by. Now, with this, let us go to the second part of this particular chapter, wherein the court may presume that earlier we had discussed from the 79 to 85, the court shall presume. There is no choice with the court, wherein the court may presume under the five categories of the cases, court may presume that the document is genuine. But however, in this category, court may allow the other party to prove. Here, the rebuttal is something less than the shall presume. This is what the difference between the may and shall presume. We have already discussed the definition may presume, shall presume, and conclude the proof. The same criteria is available that the word is used unless contrary is proved. That's why the word is used may. And the first aspect is that the court may presume the certified copies of the foreign judgment. Don't be confused between section 79 and section 86, because section 79 deals with the Indian judgment. In case of the Indian judgment of the foreign court officer, certified copies of the government office, then in such category that can be shall presume. But however, it is judgment of the foreign court, then court, it's a choice of the court. Court may presume, or court may call the party who will produce him to satisfy himself to produce other kinds of evidence to satisfy that whether the particular judgment is genuine or it's a judgment is genuine or not. Similar in case of the next aspect, that is with reference to section 85 and 86, that 86 80 87 deals with the books, maps, and the plans. Now, or the chart rather. Don't be confused between the earlier chapter, that is the earlier part we have discussed. Those maps, those charts, or those plans are the government plans. In this case, it's a plan. It's not a government. Or it's not a books. It's not a legislature books. It's a reference book. Like we have so many reference book in our syllabus. So the material which is written in the reference book, the court may presume. It's not a shall. However, when the official gazette copy of the legislature has been produced on the record, it's a shall. When it is a reference book, it may. It's a government gazette, it's a shall. This is the difference between the may and shall. Same in case of the government map, it's a shall. It's a private map. The court may presume, and in case of the chart also, court may presume. Similarly, in case of the telegraphic message, now this is something interesting and very debatable issue, because under section 88 these particular provisions are made. The court in one side is saying, uh, when might be most of you, when you start the practice in the appellate court, high court and supreme court, you might be going to face this particular problem, which personally being a student of law, I realize this might be a very debatable issue, because see here under section 88, the presumption, the word is used may, whereas if you remember under section 65b and a of the Indian Evidence Act where discussed, it's a mandatory on the court of law take the evidence. Whereas here it is said, if there is a telephonic message, court may presume. This particular confusion in the minds of the legislature is only because of that there is always a chance of adding, substituting in the electronic message, and therefore still today, even today also under section 88, whenever there is an electronic message is that there, the word is used, court may presume that they are correct, or the sometimes it happen that suppose under section 27 of the under section 27 of the act, not only the Indian Evidence Act, but the under section 27 of the one of the I will repeat the act. That act is deals with the presumption of the service of I'm sorry, General Clauses Act, section 27 of the General Clauses Act. It provides that if the notice by mentioning the proper address is sent to the particular person, then court can presume that it has been delivered. So that presumption is available under section 27. The same criteria is mentioned under section 88. If the notice is sent by mentioning the proper address, then court may presume that it is delivered during the course of the time, unless contrary is proved. If the other party is saying that, sir, my address is not correct, they is not correctly mentioned, then it can be disproved by the party. So these kind of provisions are made. Same in case of the electronic evidence also, amendment is being carried out under section 88A. And in case of the next aspect, that is a rather last part from this chapter, that is presumption as to due execution of the documents, and the document which is not produced. That this kind of aspect is very technical one, and I will give the example. So, in order to understand you people how this can be done, say for instance, if the party is asked to prove or to produce the document, and if that original document is not produced after giving the notice under section 66 of the Evidence Act, and let us take one example so that you understand. The dispute which I discussed between A and B, the document is in possession of B. A issues the notice. B has not produced the documents. Secondary evidence is allowed by the court. In such cases, under section 89, the court may presume that the document is particularly presumed. So that presumption, if the secondary document is there, that presumption is in respect of execution of document. If suppose that the other party is saying, sir, it's a fraud, then he has to step into witness box. He has to come and he has to produce the evidence in the court of law. And lastly, the last presumption, that is with reference to section 90. If the document is old, more than 30 years, if it is registered as per the procedure of the Registration Act or Transfer of Property Act, that is it duly registered, duly amply paid, then courts are presuming that if the document is 30 years old, court may presume that the document is genuine, because this section is based upon the natural theory of the natural tendency of the human being. that if the document is not genuine, then no ordinary person with the prudent man will wait for 30 years. And therefore, whenever there is a 30 years old document, it is duly executed, signed by the party, then court may presume that particular document is genuine one, unless contrary prove that the other party that it is fabricated or false document. So all these aspects, so far as the presumption of documents are concerned, are provided under section 79 to 19 of the Indian Act.